Hi, today we're going to talk about how do you get awarded attorney's fees in a family law case. Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida. Welcome to the Healthy Family Law Attorney. Today I'm going to help you by letting you know what are the factors the court's going to look at in awarding attorney's fees. So the main statute is 61.16 of the Florida statutes. It says basically the court's going to look at the financial resources available to the parties when deciding whether to award attorney's fees. So what does this mean? It looks similar to alimony, where if you look at a prior video I did, the court looks at the financial ability of one party to pay and the financial need of the other party to pay. All right. In alimony, it's a more in-depth and additional discovery or determination of what are the other factors under that statute. If you want to look at that prior video, it's 61.08. So family law is different from other areas of law, such as personal injury or contract law, where the prevailing party is awarded attorney's fees. In family law, it's not who wins and loses as much as it is who has the ability to pay the fees and who has the need to receive them. So how do you prove that? How do you establish that in court? Well, your attorney will need to file an affidavit of attorney's fees along with all of the billing statements you've received in the case, which should be detailed enough that it shows the court not only how much time for each separate task was billed, but actually what itemized, detailed work was done for the client in the case. So the other side is going to often attack that and say, well, does your attorney have the necessary experience? Has he or she been an attorney the requisite number of years to have that a billable hourly professional rate? Okay. Also, the other side's going to look at the actual work done. And so this is a good practice pointer for the client. The other side's going to look at, did your attorney just simply engage in hand-holding? There's a lot of emails going back and forth where your attorney was reassuring you about different concerns or worries or fears you might have had in the case? Or was it legally justifiable or required for your attorney to give you that legal advice? Did your attorney bill for actually drafting motions or pleadings or drafting discovery documents like interrogatories, requests for production, requests for admissions, and so forth? If your spouse has the financial ability to pay, the court, and you have the financial need to receive, the court will order attorney's fees in some amount within the court's discretion. So there's never a guarantee that the court's going to award fees. The court can award attorney's fees on a temporary basis or on a permanent basis. So it's not based on who wins or loses, it's based on the financial resources available to the parties, and attorney's fees can be awarded at really any juncture in the case. So attorney's fees can be awarded in a dissolution of marriage matter, i.e. a divorce, can be awarded in a paternity case, can be awarded in a modification case, an enforcement case, anything like that. So ask your attorney about that if you're going to need assistance from your spouse or significant other in order to pay your attorney's fees. Okay, so finally, a lot of people will tell you you need a financial expert to establish the amount of the fees and so forth. No, that's not the case. Clearly, the statute 61.16 says you don't need a financial expert to testify. Okay, so now there's a second area in which you can get attorney's fees, and this is not based on financial need or ability. This is not under Chapter 61.16. This is in the area of sanctions. This is where your spouse or significant other has refused to abide by a court order, has refused to produce documents as they are required in the case. Mandatory disclosure is like it sounds, mandatory. If they're not producing it, then they can be sanctioned by the court. If they haven't provided documents in response to a request to produce or interrogatories or other discovery, as I previously mentioned, then your attorney can seek sanctions against the other side for that and get attorney's fees. Those attorney's fees are limited to what is being sanctioned. So it can't be for a lot of other things like just general advice from the attorney or concerns about time-sharing issues or other questions that you might have for your attorney. It would be for dealing with the failure to produce a document or dealing with the failure to abide by a court order and for having to draft the motion and go to the hearing. Okay, so it's more limited. The attorney fee request under Chapter 61.16 is typically sought in a motion for temporary relief after mediation in the case, or can be a straight motion for attorney's fees. And that's for all of the attorney's fees up to that point in the case, and even for attorney's fees to help you provide for your defense or prosecution of the case moving forward into the future. Okay, one last thing on sanctions, which don't require showing of financial ability and financial need. The fees still have to be reasonable. They're still going to be questioned by the other side. And so you should make sure that when you call your attorney, it's for something that's really necessary. It's for something that'll move the case forward. It's something to assist your attorney in providing the representation to you. Okay, so try to keep the meetings short and to the point, or better yet, I like to see emails from the client with bullet points that lay out exactly what are the questions or what is the information that the client is providing that can be read by the attorney more quickly and maybe responded to in an email by the attorney. That way the client actually has an electronic paper trail there, so everybody knows that issue has been discussed. Harder to know from just a telephone conversation, which might take longer and cost more. Okay, so finally, there's a couple of other areas where you can seek attorney's fees in your case. One is under Florida Statute 57.105. That is a very powerful statute. It's not used that often, but the really powerful thing about it is if you utilize that provision of the Florida statutes, you're not only seeking attorney's fees against your spouse or significant other, you're seeking attorney's fees against the opposing attorney. Let's explain. How is that possible? So basically, the statute says that if your spouse and his or her attorney have filed a frivolous case, it's not supported by the material facts and law that it should have been in order to bring it forward, the court can, in essence, sanction not only your spouse or significant other, but also opposing counsel. So let's say in this case, the other side has brought a case that is just frivolous. So what your lawyer has to do is send basically what's called a safe harbor letter or a 21-day letter. And so what that does is it gives the other side 21 days to fix whatever they've done, withdraw it, change it, whatever, make it in compliance with what the law is. If they don't, then you can file the motion after the 21 days has expired and seek those fees not only against your spouse or the other side, but opposing counsel. All right. Finally, there is some very powerful case law which has been ruled upon by the Florida Supreme Court. The seminal case is Rosen v. Rosen. That's a case that can be used in way of defense against a request for attorney's fees. These are some things that you should know and your attorney should talk to you about. So I hope this has been helpful. If it has, please hit that like button. I would love for you to subscribe to the channel, hit that bell icon so you never miss another video that comes out every Wednesday, and of course our interviews that come out on Fridays. I hope you are receiving these, that they are providing hope and help to you in your case. If you have any questions or comments, please put them in the comment section below. That would be great. I'd love to see you in the next video with the Healthy Family Law Attorney. Thanks.